Hello, good morning students. Please subscribe the channel, drop a like, share and comment. This is Shree Vishnu Art Press Publications, exercise number 5 and 6 on the speed of 90 words per minute. Start. There is another aspect of the matter which disentitles the appellant from seeking the relief of divorce on the ground of desertion in this case. As desertion in matrimonial cases means the withdrawal of one party from a state of things, that is, a marital status of the party, no party to the marriage can be permitted to allege desertion unless he or she admits that after the formal ceremonies of the marriage, the parties had recognized and discharged the common obligation of the married life, which essentially requires the cohabitation between the parties for the purpose of consummating the marriage. Cohabitation by the parties is an essential of a valid marriage, as the object of the marriage is to further the perpetuation of the race by permitting lawful indulgence in passions for procreation of children. In other words, there can be no desertion without previous cohabitation by the parties. The basis for this theory is built upon the recognized position of law in matrimonial matters that no one can desert who does not actively or willfully bring to an end the existing state of cohabitation. However, such a rule is subject to just exceptions which may be found in a case on the ground of mental or physical incapacity or other peculiar circumstances of the case. However, the party seeking divorce on the ground of desertion is required to show that he or she was not taking the advantage of his or her own wrong. In the instant case, the appellant herself pleaded that there had not been cohabitation between the parties after the marriage. She neither assigned any reason nor attributed the non resumption of cohabitation to the respondent. From the pleadings and evidence led in the case, it is apparent that the appellant did not permit the respondent to have cohabitation for consummating the marriage. In the absence of cohabitation between the parties, a particular state of matrimonial position was never permitted by the appellant to come into existence. In the present case, in the absence of cohabitation and consummation of marriage, the appellant was disentitled to claim divorce on the ground of desertion. No evidence was led by the appellant to show that she was forced to leave the company of the respondent or that she was thrown away from the matrimonial home or that she was forced to live separately and that the respondent had intended animus disrendi. There is nothing on record to hold that the respondent had ever declared to bring the marriage to an end or refuses to have cohabitation with the appellant. As a matter of fact, the appellant is proved to have abandoned the matrimonial home and declined to cohabit with the respondent, thus forbearing to perform the matrimonial obligation. In any proceedings under the Act, whether defended or not, the court would decline to grant relief to the petitioner if it is found that the petitioner was taking advantage of his or her own wrong or disability for the purposes of the reliefs contemplated under Section 23(1) of the Act. Being aggrieved, the appellant SSC preferred an appeal before the Commissioner of Income Tax. The Commissioner of Income Tax wide order dated 4/4/1988 partly allowed the appeal. The appellant SSE and the respondent Income Tax Department, feeling aggrieved against the order of the Commissioner of Income Tax, filed two separate appeals before the Income Tax Appellate Tribunal. The tribunal, by order dated 19/8/1993, without going into the merits of the case, set aside the assessment order and remanded the file back to the assessing officer to re-scrutinize the entire accounts after giving the appellant SSC an opportunity of being heard and also giving the appellant SSC an opportunity of filing any evidence in support of its claim that there was no discrepancy in its accounts as pointed out by the assessing officer or as found out by Commissioner of Income Tax in his order dated 4/4/1988. On remand, the assessing officer issued summons to 10 traders under Section 1311 of the Act. In response to the summons, 5 traders appeared and gave evidence in favor of the appellant SSE. The remaining 5 traders did not appear because they could not be served with the summons as they were residing outside the state of UP. The assessing authority has drawn adverse inference against the claim of the appellant assessee and assessed rupees 230,704 as total income for the assessment year 1984-85, treating the transaction with the absentee traders as having been done by the appellant SSC in the capacity of trader and not as commission agent. The revenue, feeling aggrieved, preferred an appeal before the Income Tax Appellate Tribunal. The tribunal, by its order dated 15/1/2004, allowed the appeal and held that the appellant SSC has failed to produce any evidence that the transaction in question were not conducted by the appellant SSC as Vyapari, but the transactions were conducted on commission basis. Being aggrieved against the said order, the appellant SSC filed income tax appeal before the High Court. The High Court, as noticed above, has concurred with the findings recorded by the assessing authority as confirmed by the appellate tribunal and dismissed the appeal in limine. Now, the appellant SSC is before this court. The learned counsel for the appellant SSC submitted that the High Court has committed grave error of fact and law in dismissing the appeal in limine without proper appreciation of the facts and legal proposition of law. According to him, for non appearance of the traders summoned by the assessing authority, no fault could have been laid upon the appellant assessee and the assessing authority. The appellate tribunal as well as the High Court are not justified in drawing adverse inference against the appellant assessee, holding it to be trader in relation to the transactions conducted by the appellant assessee of the same goods in the same manner as was conducted with the traders whose evidence was accepted by the assessing authority.